Welcome everyone to today's Employment Law Lunch and Learn presented by Kelleher and Holland. Our topic today is reductions in force. Setting the table for our discussion today are Andy Bowling, Maura Ann McBreen, and Madeline Kelleher, all members of our employment law group here at KH. So Andy, can you get us started with an introduction to today's topic?
Sure, thank you, and welcome everybody to our program. Today, we're going to be tucking into a critical topic that many organizations, regardless of size and industry, have to face at some point in time. And frankly, we're seeing some of our clients, looking at this right now due to uncertainty over tariffs and other economic conditions. And that's reductions in force or downsizings. When we talk about reductions in force, we may sometimes use the acronym RIF. You may see that too in different articles or writings about the topic. And while layoffs are often driven by economic or operational necessity, they can carry significant legal and reputational risks. And one misstep can result in discrimination claims, contract disputes, or non-compliance with federal and state laws. You may have the authorities knocking on your door, literally or figuratively, if you don't do a reduction in force the right way. And whether you are simply planning or thinking about a reduction in force, or maybe you're managing something that you did within the last few weeks or months, or you're thinking about, could we do this? Our hope is that today's presentation will give you some practical knowledge on how to move forward with clarity and confidence. Now, a couple quick exceptions to our program. Our focus is on private and public companies whose workforce is at will, because unionized workforces are subject to special rules and contracts, and the same is true for public employees. Our remarks will really not be targeted at that specific sector.
All right, thank you, Andy. Let's dive in. So our first question today is, what is a reduction in force?
So a reduction in force is the group elimination of employment positions due to business needs, restructuring, or economic pressures. It can involve involuntary permanent layoffs or long-term furloughs, or even involve voluntary buyout programs or reduced work weeks. Unlike performance-based terminations, reductions in force are not based on employee conduct. They can be spurred by several reasons, such as cost savings, elimination of redundant roles, or operational restructuring. No matter the reasoning, it is important to consider the legal implications and have a proper plan in place to protect the company from unwanted and unnecessary outcomes.
So Madeline, do employers need a legal reason for a reduction in force?
No, they don't. Just a specific legal justification is required. However, when the need for a reduction in force arises, employers should identify a legitimate business reason driving the reduction and clearly document these reasons. For example, budget cuts, or corporate restructuring. In doing so, the company should document why other less drastic measures, such as hiring or promotion freezes, reduction of employee hours, or transfer of employees to other locations are infeasible or insufficient to avoid implementation of the reduction in force. This step will be critical if decisions are later challenged and will help defend against potential discrimination or wrongful termination claims.
And what are the legal risks associated with reductions in force?
Great question. Any company that is considering the implementation of reduction in force should ensure that the planned reduction is in compliance with the U.S., federal, state, and local legal requirements, as there are many laws governing the structure and implementation of this method of personnel reduction. While there are a variety of risks that come along with terminating employees, some of the most common legal risks an employer may run into conducting a reduction in force include discrimination claims, which could be brought based on age, race, gender, disability, etc. Retaliation claims, especially if recent complaints or leave occurred. Breach of contract claims if employment agreements or policies are not followed. and WARN Act violations, which we'll discuss later on in this presentation.
Great. So Andy, what are the key considerations in deciding the necessity of a reduction in force?
Well, I think before you decide to, push the go live button, you really need to be able to answer, the following questions. And these are questions that are raised internally among a key group of corporate decision makers, hopefully for reasons that we'll talk about a little later, with a lawyer involved to protect such discussions from legal disclosure. But answer number one, why is the reduction in force necessary? And what can we document to justify a decision to reduce the size of our workforce? Number two, how will we select employees that will be selected in the downsizing? And number three, how will the company treat people who are selected for inclusion in the reduction? In other words, what happens to the people who are fired? And I know I'm going to get pushback because a lot of my clients do when I tell them this, but our people are employed at will. We can do whatever we want. And you know what? Technically, legally, you can. Mm-hmm. But our advice is grounded in practical experience. And we know as much as you love your lawyers, you prefer to minimize those billable interactions. So if you want to disregard our advice, that probably means you've got a lot of meetings with your legal counsel in your future after the event. This is in the reason why we want to answer these questions and have the documentation and decision making available for people to see is that ultimately, if an employee files litigation or makes a report to a government agency, you really need to be able to show that you did this in a very thoughtful and legally compliant way, and that you looked at other options to avoid the significant impact of someone losing their job. Courts, juries, and government agencies are much more likely to respect a well-documented and well-planned reduction in force. If they see something that is done on the back of a napkin the night before people were fired, that's going to be difficult to defend. And so to reduce these risks, we really recommend that companies, take this careful planning and enact the measures we'll be talking about.
All right, so let's jump into the key considerations that need to be thought about when selecting the employees for the reduction in force.
And again, I'll preface my comments by saying, technically, you don't have to do this unless you like litigation and like dealing with lawyers. But if you don't, and you want to minimize risk, we suggest that when you decide to select individuals or put the spotlight on specific departments who are going to be impacted, that you develop objective selection criteria that are given to the decision makers before the decisions are made. And this can be skills, performance, and seniority. And when we talk about seniority, low seniority is a good reason. Picking people because they have the most seniority is generally going to be a problem. And the criteria should also align with the business rationale that are driving the layoffs. Are you being impacted by tariffs? Have you lost some key customers? Do you need to introduce more technology into your workplace? And you've got to make sure that your justifications that you select remain valid with respect to the reduction in force and the number of employees who are affected. And you should always avoid using subjective or inconsistent criteria. In particular, please don't talk, worship, write about someone's age, gender, race, religion, or disability status, because that creates a number of smoking guns that will be turned against you in litigation. You also need to consider whether an employee is on a legally protected leave of absence, such as Family Medical Leave Act. Now, there may be situations where someone on a leave can be let go if they would have lost their job otherwise, and other people in the same unit are being terminated. But evaluate that just to make sure you're not surprised. And you should also look at your handbooks. Some companies may have a provision that introduces a series of due process rights for employees. We've seen that. And there may be some individuals with employment agreements who aren't quite at will. And you want to determine, are there any contractual limits on our discretion?
So Madeline earlier mentioned the WARN Act. What is that act and what does it require?
Okay, the WARN Act was invented with a federal law, the Workers Adjustment and Retraining Notification Act. It's been around for over 30 plus years. And if you're covered, you can still do a mass layoff or a plant closing, but you have to give 60 days notice ahead of time. And who is covered? I'm going to give you just a few benchmarks. If you have 100 or more employees, yes, you better think about the Federal WARN Act. Number two, if you're covered under the Federal WARN Act and you're going to be letting go 50 or more people, you need to think about your WARN Act obligations. Mm-hmm. And then it's not just the Federal WARN Act anymore. States like California, New York, Illinois have what they call mini WARN Acts, but they're actually even more oppressive and more limiting than the federal law. Just Illinois, for example, here are the key benchmarks if you're an Illinois employer. Do you have 75 or more employees? Then, yes, you are a covered employer under the Illinois WARN Act, even though the federal law doesn't apply. And if you're planning to terminate 25 or more people, look at your WARN Act obligations under Illinois.
So Madeline, should employers offer severance when conducting a reduction in force?
So while offering severance to the employees selected for this reduction in force is not required, we always recommend doing so in exchange for a release of claims against the company. We generally call this a severance and general release agreement, but for purposes of this webinar, we'll refer to them as severance agreements. Of course, providing severance packages to all employees terminated as part of the reduction of force can be an expensive proposition, but obtaining a valid release of all potential claims by terminated employees in exchange for valuable consideration like severance will help to prevent employees from later litigating against the company. It's important to note that even though a severance agreement is offered to an employee, it does not necessarily mean that the employee will sign it and release the company from claims that occurred during their employment. However, in our experience, it is more likely that the employee will take the severance rather than lose the chance and gamble on a possible payout via a lawsuit or government agency proceeding. Some of the key statutes and regulations one must consider in preparing severance agreements include, but are not limited to, Section 409A, which governs the timing of severance for certain highly compensated employees, the Older Workers Benefit Protection Act, which I will discuss later in this presentation, the Age Discrimination in Employment Act, and laws governing restrictive covenants. An important consideration here is that a release of all claims will inhibit the employee from bringing most, but not all claims against the company. Some claims cannot be waived, including those related to workers' compensation, unemployment insurance, unpaid wages, including overtime, and the right to file a discrimination charge with the Equal Employment Opportunity Commission, to name a few, as the corresponding laws prevent waiver of such claims. From our perspective, obtaining legal counsel to assist with preparing severance agreements is imperative to ensure they are effective and lawful and can be enforced. We've seen far too many severance agreements in our experience that are illegal and unenforceable, leaving companies helpless in protecting its interests, as well as liable for the illegal provisions and any attempts to enforce them.
So you just mentioned the Older Workers Benefit Protection Act. So let's talk a little bit about the requirements of this act when you are terminating employees.
Of course. The Older Workers Benefit Protection Act must always be considered when providing an employee with a severance agreement. There are special requirements with respect to separation agreements, waivers, and releases for workers over the age of for workers the age of 40 or over due to the federal statute known as the Older Workers Benefit Protection Act. The primary purpose of this act is to ensure that the employees age 40 or over do not waive any potential age discrimination claims unless they do so knowingly and voluntarily. The act specifies minimum conditions that must be met before a release agreement is valid and enforceable, including the release agreement being written in a way that can easily be understood by the worker, specifically referring to rights or claims arising under the Age Discrimination in Employment Act, so that the worker is made aware of their rights. The worker cannot be asked to waive future claims that may arise after the date of the release is executed. And in return for signing the release, the employer must give the worker something of value above and beyond what that worker is already entitled to. The worker must be advised in writing to consult with an attorney prior to executing the agreement. The worker must be given at least 21 days within which to consider the terms of the agreement, and the release must provide that for a period of 7 days following the execution of the agreement by that worker, the worker has the right to revoke the agreement for any reason if they have second thoughts, change their mind, and that release will not become enforceable or effective. The Older Workers Benefit Protection Act is even more onerous in its requirements if the release is proposed to a group of older workers in connection with a plant closing or a reduction in force. In such a situation, each worker in the group or class of employees must be given a period of at least 45 days, not just 21 days, within which to consider the release agreement. There's also additional notice and disclosure obligations concerning ages, job titles of all persons affected by the group layoff and not affected by the group layoff. These notification memoranda are required by law to be furnished to every single employee in the company and not just those included in the reduction in force. As should be apparent, the process of obtaining severance agreements in the context of a reduction in force can be quite complex. One concern commonly raised by employers is that if a worker takes the proposed release to a lawyer within that 45-day period, the lawyer will advise the worker to pursue a strategy of threatening litigation to obtain more money from the employer. While this is a valid concern, employers are well served in obtaining a release from terminated employees in the reduction in force context wherever possible.
Maura Ann, so tell us a little bit about what is required under COBRA when an employer is conducting a reduction in force.
Okay, thank you, Amy. Under a federal law known as the Consolidated Omnibus Budget Reconciliation Act of 1985, which is commonly referred to as COBRA, an employer is required in most circumstances to provide a terminated employee with the opportunity to purchase retirement replacement health insurance coverage. The law requires employers to give notice to employees of their right to the replacement coverage for a period of up to 18 months at 102% of the cost. The coverage must be the same as substantially similar employees who are active in their employment. So if you've got an active employee, you've got to be providing the same coverage. Many employers tend to administer their health insurance plans through the use of a third-party administrator. These third-party administrators typically handle providing the required COBRA notice and offering continued health care coverage to departing employees. However, the duty is that of the employer. If the company fails to fulfill its COBRA obligations, it may be exposed to significant damages, penalties, and fees in an enforcement action. So it's a duty of the employer, not the third-party administrator. The employers should also check their state and local laws, as some states and local jurisdictions, like Illinois, have mini COBRA acts. that may have different requirements and that have to be adhered to.
Great. Andy, what impact will a reduction in force have on unemployment insurance?
The short answer is, depending on the number of employees you lay off, there may be a spike, an increase in your loss rating for unemployment costs, but it's not going to be that significant. Generally, employees who are laid off due to a RIF are entitled to unemployment. In some states like Illinois, employers are required to notify employees of how to apply for unemployment compensation. And even if you give the employees severance under a release, as Madeline talked about earlier, they still have that right to kind of double dip, if you will, and collect their unemployment benefits.
More, Ann, what benefit and ERISA considerations are there?
All right. The company implementing a reduction in force will be required to fully comply with any benefit obligations imposed under the terms of its employee retirement or welfare plans, including any requirements pertaining to the withdrawal from such benefit plans. So, in other words, an employer must follow its plans and what benefits they provide upon termination of the plan, if that's what's being done. The employer has to do this, and it's a risk of the employer in terms of not fulfilling their ERISA obligations. And ERISA is the Employee Retirement Income Security Act of 74.
So, Andy, what about immigration status? Are there any issues to consider here?
Yes. If you have an employee who is working under a visa that was obtained by the company for the benefit of the employee, there are issues. As a general rule, you need to look at employees who are on a visa. You may be required in certain circumstances to send them back to their country of origin fairly quickly. And so, in addition to looking at the financial impact of losing the employee, you may have to send someone back to India or Pakistan or England, depending on their country of origin. Another issue that employers sometimes seem to forget is if you're trying to do something short of a downsizing, such as we're going to cut everybody's pay by 10%. In order to ride through an economic crisis, you can't usually do that for someone who is on a visa, because you are representing to the government that they are going to be paid at a certain rate, and there are restrictions on your ability to reduce that compensation rate.
All right, how about us? At what point would an employer want to involve legal counsel when they're going through one of these reduction in force processes?
I personally think, and I obviously have a vested interest, but I think if you want to minimize your involvement with lawyers and reduce your litigation risk to the maximum possible extent, once you have decided as the owner of a business or as a key decision maker, a C-level executive within a business, that you need to make cuts, I would have your lawyer present. And this is because, number one, the lawyer can help deal with the selection criteria, help document the internal, sometimes CYA documents. This is why we're doing a RIF. But more importantly, having a lawyer present with senior managers means that there can be robust discussion about various individuals or decisions, and those discussions are generally protected under the attorney-client privilege. If the lawyer's not in the room, you may think you're having a confidential discussion with your CFO and head of HR, but nothing that is discussed is immune from discovery to the government or to an opposing counsel. And there's another really important issue where lawyers can add value. And this is, if you're doing a big cut, it's always a good idea to do a snapshot of your workforce. In other words, you're going to have certain percentages of women, racial minorities in your workforce. And ideally, after you make your selection criteria, those percentages will be roughly the same.
Mhm.
And that statistical review should only be done under the direction and control of an attorney, because you do not want the rank and file managers to be aware of that testing. Now, the federal government, the current administration, has said that disparate impact, what happens if an inordinate number of women are included in a reduction in force? They're saying that's no longer relevant, but it is very relevant under the State of Illinois Human Rights Act, under most state laws, under City of Chicago and Cook County laws. So that statistical review is a great idea, but it's a no-go if there's not a lawyer involved to provide some protection over that process.
All right. What haven't we talked about yet in this discussion, Madeline? Are there any other additional considerations that people should be thinking about when implementing a RIF?
Yeah, I've got 6 additional considerations to discuss. One, establishing a committee of legal staff, human resources officials, or other representatives to assess the manager's initial selection of employees for a reduction in force will help decrease the likelihood of discrimination in the decision making. Second, assessing the impact of a reduction in force on remaining employees and any retention programs for key employees and on relationships with vendors, customers, clients, and other stakeholders is an important thing to do. Should also prepare a communication plan and or public relations strategy. Having a plan regarding remaining employees, customers, stakeholders is very important as well. Public company employers should assess whether a Form 8K disclosure with the Securities and Exchange Commission is required. 5, meeting individually with each affected employee, although not legally required, may help to explain the reason for termination, present the separation documents, and discuss the return of any company property and other administrative tasks ahead of departure. Consider also providing access to counseling services to employees included in the reduction in force and working with and providing extra support to social service organizations within the geographic areas impacted by the reduction in force, since the occurrence of this reduction in force frequently triggers sharp increases in child, spousal, and substance abuse. Those are the few little things to consider.
We've got 1 minute left. Madeline, did you just want to wrap it up for us?
Yeah, absolutely. So if you're going to remember anything about today's presentation, the most important takeaway is to plan ahead, document your decisions, and involve legal counsel early. Never underestimate the significance of being proactive and seeking legal counsel in all employment situations, so you don't have to be reactive about with the mistakes that are made along the way that could have been avoided, which will in most cases be more costly than having paid an attorney for help in the first place. A carefully executed reduction in force protects both businesses and its reputation.
Great. Thank you, panelists, for your awesome presentation today. And thank you, viewers, for joining us today. You can contact any of our speakers directly for further guidance. We are here to help you. So watch your inbox and our social media pages for details on our next webinar. And thank you again for joining us. For more information on our employment law services or any of our other practice areas, visit kelleherholland.com or send us an email to attorneys@kelleherholland.com. Kelleher & Holland's Employment Law Lunch and Learns are prepared for the general information of clients and friends of the firm. It is not intended to provide legal advice with respect to any specific matter, nor is it intended to create an attorney-client relationship. Under rules applicable to the professional conduct of attorneys in various jurisdictions, this may be considered attorney advertising material.